All right, and we are live. So, as we're getting warmed up here, I want to welcome you. We're going to be doing this one in English. So, this video today, we're going to be doing in English for our English speaking audience. As we are doing our show today here on the Prima Law Podcast, I want to encourage you to do the following. I want to encourage you, if you have any questions, if you're curious, you have questions or comments, go ahead and throw those in the comments. I will be taking a look at those after my main presentation is over. We will take the time to answer some questions. And again, we hope you enjoy the show. All right, welcome back to the Prima Law Podcast. I am your host, attorney James Betzold. I'm an immigration attorney with over 16 years of experience uniting families through immigration. And what we're going to do today is we're going to talk a little bit about some of the court decisions that have been going on. There are court decisions that are new this week affecting some of the things you're seeing in the news today that are shockingly abhorrent. Okay, because it has to do with people being taken, being kidnapped, being pulled off the street by people in masks who work for our government. And it's quite shocking. So there are a couple decisions coming out of Chicago, things that have happened recently there. We are going to cover that. We're also going to cover some good news coming out of Detroit, because the government recently said we're going to apply a new standard. We're going to try and apply a whole different law to people who are living in the United States when they're picked up by immigration, and we want to deny them the opportunity for a bond hearing. Now, the way that the government is doing that is unlawful, so there have been lawyers who took this to court. The ACLU was involved with that. Great work, guys. In the Eastern District of Michigan, they filed what's called a habeas corpus petition, which gives us the ability to have the body, right, to take the person out of custody. And there was some great relief granted in those cases recently as well. So we're going to be discussing that. Now, as always, our show is brought to you by Prima.law. Now, Prima.law is immigration case management software for immigration attorneys and immigration professionals. It is the software you need in order to assemble those petitions that you need to submit, and also to submit them to the government, whether you're printing it using our PDF package assembly tool or whether you're submitting it via e-filing with our e-filing tools. You can find a free 15-day trial at www.prima.law, and it's not just for assembling your petitions. It is for managing your whole practice with a whole suite of tools, including trust accounting, bill payment. So you can send a bill to your client and they can make electronic payments to you. We have a full client portal that makes everything nice and easy. Again, find a free trial of that at www.prima.law. Now, let's get the show started. Okay, so the first thing we were going to discuss today is some of the recent events happening over in Detroit, and we have a habeas corpus petition. Okay, and in summary, like I was saying, a habeas corpus petition is something you would file in federal court when the government has taken a person and the attorney, or you believe that that is unlawful, right? So it's sort of a fix-all in many situations where somebody's been taken and imprisoned. Maybe they've not been read their rights. Maybe they don't know why they're imprisoned and nobody's told them why. Or maybe they got picked up off the street by ICE and now they're detained and now they don't know what to do about it and there's nothing that they can do about it. So what do you do in those situations? You go to federal court and you file a habeas corpus petition. And that's what was done here. Now, let's pull open some information on that I want to share with you so much because it deals with some real people. So who are we talking about here? The people we're talking about in this case, oh, I lost my spot. And it's going to be here. All right, found it. And maybe some of them are listening today because we know they were granted hearings. Jose Daniel Contreras Cervantes. This is all public information. We're not doxing anyone, just so you know. A citizen of Mexico and U.S. resident since 2006, lives in the U.S., wife and 3 children. He suffers from chronic myeloid leukemia. He has no criminal history and was arrested by Border Patrol after a traffic stop. You have Freddie de Los Angeles Flores, a citizen of Mexico, U.S. resident since 2010. He lives in Pontiac with his U.S. citizen son. No criminal history aside from minor traffic infractions and was arrested by ICE ERO at a gas station. We have, we'll just use first names now. Mariela, a citizen of Venezuela, living in the U.S. since 2021. She was initially dismissed from removal proceedings because she has TPS. She has no criminal history aside from minor traffic infractions and was re-detained after being arrested during a traffic stop and later reported to ICE for a check-in. So these are individuals who ICE ended up detaining them and then denying them a bond hearing. An individual by the name of Debbie, citizen of Mexico, living in the U.S. since 2016. She lives in Detroit with her U.S. citizen daughter, no criminal history, encountered by Border Patrol in Port Huron. Jairo, a citizen of Guatemala, living in the U.S. since 2018. He is a victim of a felonious assault, is participating in a victims program. He has no criminal history and was encountered by ICE while driving in Wixom, Michigan. Marifer Diaz Alcantar, citizen of Mexico and U.S. resident since 2003. I say resident. This is not legal status. This is living in the U.S. since 2003. She lives in Detroit and has a pending DACA application. No criminal history. Was taken into custody by Border Patrol after a routine traffic stop. And we have one more, Miguel Angel, a citizen of Mexico, U.S., living in the U.S. since 2000, lives in Detroit with wife and 2 U.S. citizen children. Pending applications for asylum, cancellation of removal, no criminal history, and was arrested by ICE enforcement and removal officers. Okay, so these are the people who this complaint concerned. And this is a complaint that was filed in the Eastern District of Michigan. It was brought before U.S. District Judge Brandy R. McMillan, and he ended up granting the petition for writ of habeas corpus filed by these 8 individuals. They were apprehended by immigration authorities here inside the U.S. So it's not like they were crossing the border and decided to enter. It's not that they were on a flight, traveling, crossing the river, swimming from Canada to Detroit. No, that's not the case. It's not that they were an arriving alien by any means or stretch. They were here living already in the United States for many years, most of them over a decade. Okay, the court found that their mandatory detention was unlawful. Now, when we talk about mandatory detention, if you're an immigration practitioner, you understand that INA 2, I forget the quote, 236, 237, 237C, I believe it is. But there's a statute that says these are the individuals who are subject to mandatory detention. And people who are not arriving aliens are not included in that. So if you're not arriving to the U.S., right, found within the U.S., close to the border, or at the moment that you're crossing the border, or having just recently entered the United States, then that statute doesn't apply to you. There's other criminal things like possession of marijuana or trafficking in illicit substances that will make you subject to mandatory detention as well. But these individuals, that did not apply to. Therefore, if they're being held mandatorily and they're denied a bond hearing, that's unlawful. So the remedy is to go to federal court, petition for habeas corpus, and there you have it. You can be released or you can be granted a bond hearing by the judge. So here's what happens. They were apprehended, often during traffic stops, and detained. And despite no criminal history, no significant criminal history, some had minor traffic violations. That's not enough for mandatory detention. But they were all denied a bond hearing by an immigration judge in Detroit. And we could go look up their cases probably and find out exactly what judges they were. But at this point, it really doesn't matter which judge it was, because the policy of these judges is uniform, and they're being strong-armed by the President of the United States and the Department of Justice, because the President of the United States does not want them to have a bond hearing. He wants them gone, no chance for nothing, sayonara. That was their plan. That's what they were trying to implement. And again, we've been saying this for a long time. They've been doing that unlawfully. You can't just say everybody's subject to mandatory detention and you don't get a bond hearing. That's not how the system's built. The system is built by statute. So laws that Congress passed, it's something Congress used to do back when they could pass a law and agree on something, at least a simple majority. They could pass a statute and and the president would sign it into law. So the court ordered the government to either immediately release the petitioners or provide them with a bond hearing under 8 U.S.C. 1226A within 7 days. The court also explicitly forbade the government from continuing to detain them based on the mandatory detention statute found at 8 U.S.C. 1225 B2A. Now, let's dig into why the judge granted this petition. He says the judge ruled that the government was using the wrong statute to detain the petitioners. Okay? They're using the wrong section of law. They're applying it to the wrong group of people. And even though it does what the president wants, it doesn't do what the law says it can do. And this unlawful detention is a violation of the petitioner's Fifth Amendment due process rights. Now, one thing I had to quickly look up because I remembered from law school, there's two types of due process, right? There's substantive due process and procedural due process. So procedural due process is the government is not following the right procedures that they're supposed to in order to grant opportunities to these immigrants or to these people who've been detained. So they've been denied procedural due process. And if we say substantive due process, it just means overall, are they being shafted some other way? Okay, so they've been denied all their due process under the Fifth Amendment to the Constitution. So that's a constitutional violation. Again, one more time that the Trump administration is getting ruled against in how they are executing the laws of the United States. Now, the central dispute was over which section of the INA applied. The government's argument claimed the petitioners were subject to 8 U.S.C. 1225 B2A. This statute mandates detention for an applicant for admission who is not clearly and beyond doubt entitled to be admitted. The government argued that this applied to any non-citizen present in the United States who has not been lawfully admitted, regardless of how long they have been in the country. That was the government's argument, but it didn't fly. The petitioner's argument, right? So the ACLU, the attorneys for these immigrants, they argued that the petitioners should be detained under a different statute, which is 8 U.S.C. 1226A. That statute governs the apprehension and detention of aliens already inside the United States and allows for their release on bond pending a removal decision. This section gives them the right to a bond hearing. Now, there's a really big distinction between these two, right? Whether you're entitled to a bond hearing or whether you're not entitled to a bond hearing is a really powerful stick that the government wants to take and beat an immigrant over the head with. They want to beat you over the head with it because they know if you're stuck in detention, you want to get out of detention. Detention is not like some fancy medical club or some fancy resort that you get to stay at. And, you know, it's kind of like a camp and you get to have No, you're in prison. You're imprisoned, literally in a jail cell. Okay. And in the state of Michigan, for those of you who practice in the state of Michigan, you'll know this. The Calhoun County Correctional Facility is a county jail that leases out space to ICE. So you're literally held with your run-of-the-mill fun-time criminals from the Calhoun County area, which is Battle Creek area, or you might be detained over near Detroit. And there is a center there, which, you know, it's a jail facility. It's not a dedicated ICE facility. It is a county jail, and you're held there. Monroe County. It's Monroe County jail. If you get really unlucky, they might transfer you up to Sault Ste. Marie. Sault Ste. Marie, you say. Where in the world is that? It's on the border with Canada and the Upper Peninsula. So it's very far away. It is literally like if I was to drive from Lower Michigan here, where I'm located in Holland, Michigan, boy, that's probably easy a 5-6 hour drive in good weather. And we're not having good weather right now. So it's going to take longer. And that's driving one way. All right. So that's unfortunate if you need an in-person visit, if you need signatures on documents, if you need anything like that. It's really an effective way to deny access to your attorney, denies a client access to their attorney because you're so far away. And so a lot of attorneys won't even take those cases because it's just too inconvenient and impractical, which is unfortunate. But the difference is you're either stuck in jail for months at a time, or you say, you know what, I give up, deport me back to my home country. And that may not even be a safe option for you. So in many ways, it's a terrible, terrible, terrible way that the government will try and first demonize an immigrant and then try and oppress them into just giving up, right? It becomes a game of attrition then. So it's procedurally unlawful. It's a violation of the Fifth Amendment to the Constitution. And that's what your government has been doing because they think they're cool. But fortunately, that argument did not prevail in front of the federal judge. And now we have at least two federal judges who have granted these now in the Eastern District of Michigan. The court agreed with the petitioners and found that Section 1226A was the correct statute. The plain language rules here, right? So inspection of inadmissible arriving aliens applies to Section 1225, the one that the government wanted to use. And again, you're not an arriving alien if you've already been here. The date on that changes from time to time, but at least 2 years. If you've been here at least 2 years, you're not an arriving alien. You're just here already. Let's see here. And the Supreme Court precedent, the judge cited Jennings v. Rodriguez, which clarified that Section 1225 applies to non-citizens arriving to the country, while 1226 governs those already in the country. And the petitioners clearly fit the second category, right? When someone already has DACA or TPS or an ongoing immigration court case, they're not an arriving alien by any stretch of the imagination. And it's an abuse of police authority to try and state the contrary. Court noted that Congress recently passed the Lake and Riley Act, which amended Section 1226 to mandate detention for non-admitted individuals who have also committed certain crimes. The judge reasoned that if Section 1225 already mandated detention for all non-admitted individuals, as the government claimed, this new amendment would have been pointless and superfluous or unnecessary. And the judge pointed out that the government itself had applied 1226 in this context for 30 years and had only recently changed its policy to favor the more strict mandatory detention statute. So again, it violated due process, and that was the main argument there, and it didn't stand. And so we have a very favorable decision on habeas corpus petitions now. So if the judges in immigration court continue to decide cases in this way, if they continue to decide bond hearings in a way where everyone, even though they're not arriving, they've been here for years, they haven't committed these certain crimes that make them mandatory detention under the Lake and Riley Act or the terms previously created by statute, then we can keep going to federal court. We can keep filing these habeas petitions, and they're going to be decided quickly and in the immigrant's favor. Right now, if that immigrant assaulted a police officer or is charged with assaulting a police officer or has committed theft, right, retail fraud, under the Lake and Riley Act, those are going to disqualify them from getting a bond. Anyway, those are new changes. There's other things like, what were they? Haven't committed domestic violence or other serious felonies, other serious crimes, other serious drug crimes. They're also going to be denied bond. That's just the way it's always been for years and years and years. But saying that everyone here in the country that gets encountered is mandatory detention, that doesn't fly anymore. Now, it's going to be interesting to see because, again, the judges in immigration court, they don't answer to you or me. They don't answer in every case to the federal courts until the federal courts rule in the immigrant's favor. And this was said to me by one of the immigration judges recently. He says, look, you know what? We decide these based on the rules that we have from our boss. Our boss is the Attorney General of the United States. We have to essentially do what they say. Now, if you go across the street to federal court and they tell you something different, Well, then I have to follow that because they're the boss even of my boss. But I have to do it this way for now. So it's going to be interesting to see if the immigration court judges, not just in Detroit, but across the country, if they continue trying to implement this unlawful policy, which on the one hand, they could keep doing it until they're stopped from doing it, until there's a federal case that goes to the Supreme Court where they get it like a permanent injunction against it, which is harder to get nationwide now. You have to go get class certification first, but it is possible. So like I said, it will be interesting to see what happens there. It's definitely going to open the door for a lot of immigration attorneys, not notaries, not form fillers, but real attorneys, real red-blooded attorneys, to go to federal court, flex their muscles and say, hey, habeas corpus, we got a Fifth Amendment violation here. Judge, you've already decided this multiple times, and so have the other judges, and so have the other districts, and so have the other courts. So that is some actually really great news coming out of the Eastern District of Michigan. So with that, let's turn our attention to one of the other court cases that we've been following, which comes out of, and I actually want to turn back to a different document here. This comes out of Chicago, the Northern District of Illinois. So that's the federal Northern District of Illinois. We see that they have granted class certification. And this is kind of neat, right? I'm going to open this up here, because when you want to get a class certified in a class action type case, which is what we pretty much need to do all the time now in anything related to getting the government to stop breaking the law against as many people as possible. Since I believe the case was Trump v. Casa, since the Supreme Court said, hey, nationwide injunctions are getting abused, they're inappropriate, you can't get them anymore. So since the district court's ability to get a nationwide injunction is essentially gone, you have to file a class action lawsuit, get the class certified, which actually happened in pretty quick timing here in Chicago, in the Northern District of Illinois. So I'll just read the decision. The court therefore finds plaintiffs have met the requirements of Rule 23 and grants plaintiffs' motion for class certification. The court certifies the following class. Now, the class is just a group of people who are going to be protected by this lawsuit, whether they opt in or not, right? You're automatically included to be protected in a class action lawsuit like this. All persons who are or will in the future nonviolently demonstrate, protest, observe, document, or record at Department of Homeland Security, Immigration Enforcement, and Removal operations in the Northern District of Illinois. The court also certifies the following subclasses. The religious exercise subclass. Okay, so all persons who are or will in the future engage in religious expression in the form of prayer, procession, song, preaching, or proselytizing at the Department of Homeland Security, Immigration, Enforcement, and Removal operations in the Northern District of Illinois. There's also one more subclass called the press subclass. All persons who are or will in the future engage in news gathering or reporting at Department of Homeland Security, Immigration, Enforcement, and Removal operations in the Northern District of Illinois. Finally, the court appoints the Civil Rights and Police Accountability Project of the Edwin F. Mandel Legal Aid Clinic at the University of Chicago Law School, the Community Justice and Civil Rights Clinic at Northwestern University Law School, Lovey and Lovey, the Roger Baldwin Foundation of ACLU Incorporated, and Protect Democracy as class counsel. That, my friends, happened quickly. Class certification in a more civil party versus party, non-governmental party context can go on for years. It can be argued over for years because one side will file a motion for certification. The other side will oppose it. Then one side will try to whittle a few away and exclude a few parties. and the other side will oppose that or will not oppose it. And then they try and file a motion to exclude others. And then you have discovery going on to figure out exactly who should be included in the case and who should not be included in the case or in the class certification. So the fact that this happened quickly, I think, is a reflection of the fact that there is no nationwide or some grander injunction available anymore, thanks to that awful Supreme Court decision, which was barely a majority decision. And so I think the courts have taken the cue to say, all right, we can't do a nationwide injunction, but you know what we can do? We can do this. And so we're going to. So fantastic. That's actually great. That is the order for class certification in the Northern District of Illinois. And what's great about it too is they say all persons now or in the future, which is fantastic. You're not going to have to go back and say, hey, I'm actually a member of that class. I deserve protection under the case too. You're automatically included. You know, if there's any showing that you're included in the case, you're just included in the case. And so if you need to, you know who you can contact. We named those because the judge ordered the different migrant legal clinics, legal justice clinics, so the Chicago Law School, Community Justice Civil Rights at Northwestern, law firm Lovey & Lovey, ACLU, and Protect Democracy. They're class counsel. That means you can go to them if you need to be represented because of damages or to testify in this case. So great work on that. So that was one of the decisions on that case that came out. Now, last time we recorded the podcast, we reviewed the fact that there was going to be a hearing on a preliminary injunction order. And now that hearing's been held. And we have an 8-page order. It is a preliminary injunction order. Okay, and I'm not going to read the whole thing because that would be a little bit boring. But let's read what happened because it was granted. So it's ordered that the defendants, okay, and the defendants in this case is DHS, Department of Homeland Security, ICE, Border Patrol, Commander Bovino, right? All of them are enjoined or prevented from the following. Talking about interacting with journalists, right? They're not allowed to disperse, arrest, threaten to arrest, threaten or using physical force against any person who they know or reasonably should know is a journalist, unless federal agents have probable cause to believe that the individual has committed a crime unrelated to failing to obey a dispersal order lawfully issued to non-journalists. Okay. Federal agents may order a journalist to change location to avoid disrupting law enforcement, as long as the journalist has an objectively reasonable amount of time to comply and an objectively reasonable opportunity to report and observe. That is significant because what we saw in video is reporters in Chicago being shot with pepper balls, being shot with tear gas, being, literally targeted. You can see the agent lift their little pepper ball gun, which, let's be clear, this is not, it's a less lethal weapon, but it leaves dents in your skull. Okay. And not only that, it releases a chemical irritant, which is, again, less lethal, but it's a violation of your rights if you're just exercising your First Amendment right under freedom of the press. So there was video of that, and I'm sure the judge looked at that. Now, we can't actually get the full transcript. The transcript of the hearing is going to take time. There's a whole process for determining what should be redacted and what shouldn't be redacted. I don't know if we'll have that in time where it's going to still be newsworthy or relevant. If we do get it, we can review it because it is at the very least interesting. So that definitely played a part in it. Regarding dispersal of others, right? They're prevented from issuing a crowd dispersal order, meaning a lawful command given by an authorized federal agent for all persons to leave a designated area that requires any class member to leave a public space that they lawfully have a right to be in, unless dispersal is justified by exigent circumstances such that immediate action is necessary to preserve life or prevent catastrophic outcomes as defined by the Department of Homeland Security use of force policy, updated in 2023. Okay. Because we saw that too. And there was video of that where ICE shows up. Maybe they come outside of their detention facility in Detroit or their processing facility and say, everybody has to leave. This is a lawful order. You have to leave. Well, it's not a lawful order because they're in a public place and there's no reason for it. And so they've abused that so much that they're being prevented from doing that, which is unlawful to begin with. Like, essentially, the judge in these two things is saying, you clearly don't know the law. I'm spelling it out for you. And if you violate it, it's a violation of this court order, and I can do whatever I want to you. Well, not whatever, but the judge can take many specific actions directly against local ICE officers and those who violate these orders. They're prevented from using riot control weapons, including kinetic impact projectiles, abbreviated as KIPs, compressed air launchers, oleoresin capsicum spray, tear gas, CS gas, CN gas, or other chemical irritants, 40 millimeter munition launchers, that would be for tear gas canisters, less lethal shotguns, right? So those pepper ball or beanbag guns, which will break your ribs and knock you over and hurt you and could give you a concussion and cause brain damage. Less lethal specialty impact chemical munitions, controlled noise, and light distraction devices, flashbangs, right? So they're prevented from using these things now. Electronic control weapons, tasers, on any class member, unless, of course, there's always an unless, because they have these things for a reason, right? Unless such force is objectively necessary. And objectively means anyone can look at it and say, yeah, we had to do it. Not just, oh, I fear, so I'm going to do it. No, that's not enough. It has to be like, no, they're coming at me with a weapon. They're punching me in the head, something like that, right? Some imminent threat. So unless it's necessary to stop the person from causing an immediate threat of physical harm to another person. So they can't use those things to disperse people. They can't use those things to say, hey, get off the public sidewalk, like they've been doing, and there's video of. They're prevented from using riot control weapons, including those described above, at identified targets if it is reasonably foreseeable that doing so would result in injury to any class member. Again, unless it's necessary to stop them from causing immediate threat of physical harm to another person. Again, talking about deploying pepper spray or tear gas. You can't do that into a group of people or in residential or commercial areas, which they've done, and there's video of. Deploying, again, gas canisters, controlled noise, so flashbangs, things like that, unless necessary to prevent bodily injury or death, etc. And this is sort of like repeating itself again, just getting, the judge got really specific because they don't want to leave any wiggle room for ICE or CBP or DHS to abuse it. Again, here's this one. Here's a new one, right? ICE, DHS, all of them may not strike any class member with a vehicle unless it's objectively necessary to stop an immediate threat of that person causing serious bodily injury or death to another person. So they can't slam into your car because you're honking your horn or you got a megaphone saying, watch out, ICE is here. You're engaged in First Amendment protected speech. So there's video of that, right? I've seen it. Hopefully we can show it when we edit this thing. But there's literally ICE, they pull a U-turn, slam into someone who was following them. Then grab the lady, yank her out of the car, and arrest her. So they cause an accident, breaking the law, physically assault. It's just really nasty what we're seeing. So the judge specifically had to write that out here. Letter J, using hands-on physical force, such as pulling or shoving to the ground, tackling, or body slamming any class member who is not causing an immediate threat of physical harm to others, unless necessary and proportional to effectuate apprehension and arrest. Okay, so again, there's video of dudes getting pile driven right? Just getting tackled out of nowhere. They're on their side of the line. They're in a public space. They're engaged in First Amendment protected activity, and they're getting tackled to the ground. Now there is a protective order, a preliminary injunction that says you can't do that. And again, if this gets violated, if any evidence of that is brought to the judge, they can start imposing sanctions on ICE and DHS like crazy in the Northern District of Illinois anyway. No using chokeholds, carotid restraints, neck restraints, other restraints that applies prolonged pressure to the neck. Again, the judge had to state this because there's video of it happening. Prolonged pressure to neck. That's how George Floyd died. That's exactly how George Floyd was killed by a police officer who's in prison for using unlawful and excessive force. Using riot control weapons including those listed in the order against anyone without giving two separate warnings at a sound level where the targeted individuals can reasonably hear it, unless justified by exigent circumstances. Okay? You got to give warnings. And the warnings, here she's telling what they have to warn about. Such warnings shall explain that federal agents may employ riot control weapons or force, give the targeted individuals reasonable time to avoid the use of force, and provide a reasonable opportunity to comply. Because the judge is seeing and would think that, yeah, these guys, what they're going to do is they're going to say, hey, everybody, you got to go away. Boom, 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 boom. Right? There's no opportunity to comply. They may not seize or arrest any class member who is not resisting a lawful and authorized crowd dispersal order. Again, with the exceptions, unless they've committed a crime, for example. If they throw a rock through a window, you're going to be subject to an order. Defendants shall not be liable for violating this injunction if any class member is incidentally exposed to riot control devices after such a device was deployed in a manner that complies with this injunction. Hey, fair is fair. There is danger in being at a protest, right? Incidental damage, hard to control that. All right, to facilitate the defendant's identification of journalists protected under this order, right? Because as we discussed previously, anybody can be a member of the press. You can say tomorrow, I am starting the aluminum can media company, and I'm going to report on aluminum cans and all other things. You can legitimately have your own rights under freedom of press, under the First Amendment, because now you're a member of the press, because you've stated you're going to do it. That's all it takes. It's not regulated. So here the judge says, to facilitate the identification of journalists, the following are examples of things that indicate indicia of being a journalist. Visual identification as a member of the press, such as by displaying a professional press pass, which you can make yourself, a badge, which you can make yourself, credentials, which you can make yourself, wearing distinctive clothing or patches that identify the wearer as a member of the press, which you can buy on Amazon, or carrying professional gear, such as professional photographic or videography equipment, cameras. Other indicia of being a journalist under this order include that the person is standing off to the side of a protest, not engaging in chanting, sign holding, or shouting slogans, and is instead documenting protest activities, although these are not requirements. These indicia are illustrative, and a person need not exhibit every indicium to be considered a journalist under this order. Okay? So the judge is saying quite clearly here, hey, freedom of the press is real. And for you dummies in ICE, I'm going to spell it out for you. If you see any of these things happening, you're to automatically assume that they're a member of the press. Because, as previously stated, and as I will state over and over again, you got idiots working at ICE. You have had idiots working at ICE, and you will probably always have idiots working at ICE. which is why it makes sense to want to disband ICE, because they're a bunch of idiots. It is further ordered that all federal agents, excepting those who do not wear a uniform or other distinguishing clothing or equipment in the regular performance of their official duties or are engaged in undercover operations, I can see where this is going, must have visible identification of a unique, personally assigned, and recognizable alphanumeric identifier sequence affixed to their uniforms and conspicuously displayed in 2 separate places. The same unique and personally assigned identifier sequence must remain conspicuously displayed in 2 separate places, despite changes to a federal agent's uniform or tactical gear. They need to identify themselves. This is what we've been saying. Okay? Now, like I did say just now, ICE, they're stupid. The Border Patrol officers operating like this under Bovino, they're also stupid. Bovino himself, the commander of CBP, he is a stupid, stupid man and has not enforced this already. Okay, he put his own people at risk of assault, of shooting, of death, because they're not identifying themselves. Okay, and nobody knows who they are. And if we don't know, right, if the general public doesn't know that these are police officers, at least under color of law, fulfilling their duties, somebody's going to start shooting back. So this was a very smart request by the plaintiffs and a very smart thing to be ordered by the judge. And of course, if somebody is acting undercover, there's an exemption for that. So I don't know if we're going to see that happen in all circumstances, but my goodness, they should, because ICE doesn't really need to be undercover if they're pulling people over. If they're out in public, pulling people over where it looks like they're masked bandits kidnapping people, they need to make it clear that they're not. And they need to do that for their own safety and for the safety of the community. Okay, for these same type of agents, they will be equipped and trained with body-worn cameras. They shall activate them when engaged in enforcement activity unless exempted by CBP, ICE, or DHS policy. Okay, they weren't wearing body cameras. The body cameras protect everyone. Any law enforcement officer worth their salt knows that. But again, we're dealing with idiots here. She goes and defines what a body camera is for them so they understand clearly. She defines what enforcement activity is. Enforcement activity where they don't need to have the badge or body cameras, things that they do. So let's see, what else do we have? She also ordered that the defendants, right, DHS and ICE, widely disseminate or share or spread notice of this order. They must provide copies of this order, either electronically or in paper form, no later than 10 p.m. Central Time on November 6th, which was later last week, to all of those described below, all law enforcement personnel, officers, etc. So they have to tell everybody who works for them, hey, judge gave us this rule that we got to follow now, guys. They got to issue guidance. They got to yada, yada, yada. Okay. Okay. There we go. So that was the preliminary injunction order. That's a preliminary injunction put in place because ICE was being so abusive and violating the Constitution so much in the greater Chicago area. Now, what did ICE and DHS do as soon as they got this order? Well, what any Trump administration official working in the DOJ does. They whined about it. They cried about it like a bunch of babies. I mean, it is another significant loss for the Department of Justice under Pam Bondi and under Donald Trump. So I think we have to call them a couple of big losers at this point, because that's what they are. They are acting like losers, and they're losing like losers do. And that's not hyperbole. That is literally what happened in the case. And it is also fair for us to point out that right away they went to appeal that decision, saying it's not fair. And at the Seventh Circuit, they will be reviewing that temporarily. Bovino, the commander of CBP, who, again, I just want to point out, he is an idiot. He doesn't have to report every day on the activities to the district court judge because it would interfere with his daily duties, things like that. But the rest of the order essentially is left in place. They have to do all these things, at least temporarily, until the full thing is heard. So it's a great, that's actually a great win. It's a great win for the plaintiffs. It's a great win for immigrants. It's a great win, not just for these people that, we might look at as others. Now, if you're best friends with Donald Trump or the Trump administration, I'm frankly shocked you're still listening. But in a real sense, these are things that matter for those of us who are born as U.S. citizens. These are things that matter for those of us who need to walk through a city or who want to visit Detroit to see a concert or to take a flight somewhere or to enjoy some of the great sites, activities, museums, restaurants, and things that exist in Chicago. This is an important decision for those of us who have Latina family members, right? For those of us who have spouses who don't look as white and gringo as I do. Okay? Because it's protection. It's protection against the violation of our constitutional rights. And that's what's been happening. And if we let it slide, if we say, well, we're not going to fight it because whatever, or we don't have time, or, well, those immigrants shouldn't have even been here anyway, so I don't really care what happens to them. Well, the next person they're going to arrest is you. And ICE has arrested already a number of U.S. citizens who are essentially minding their own business in the Chicago area during this Operation Midway Blitz. They've handcuffed your children. They've zip-tied your children. They busted down your doors at 3 a.m., the dark of night. They've harassed your brown and black sons and daughters as they're walking home from school or walking to work. That's not the world we want to live in. We don't live in a world where a police officer can just randomly come up to you and say, papers, please. Show me your passport. That existed. And I know it's a trope. But that papers, please sort of thinking was the Third Reich. Okay? It's not an American value. We value our privacy. We value our liberty. We value the fact that we are not the ones with the burden to prove who we are or why we're in a given place at any given time, as long as we're not breaking the law. Okay, so for everyone who says, well, they shouldn't be here anyway, they entered unlawfully, they're undocumented or whatever, the fight that we're having here is not that. That'll happen in different decisions. That'll happen as policy and hopefully some new laws are passed that can be more favorable. What we're having now is a fight for the soul of the United States, a fight for the respect for our constitutional rights that currently the Department of Justice, the President of the United States himself, Stephen Heil Hitler Miller, Gregory Dumbass Bovino, all the things that these people are refusing to respect because they think they're tough and they're going to be badasses and go do whatever they want. I am so grateful for the judges in this case who have ruled as they have in a pretty expeditious manner, especially with the class certification. So I'm optimistic. That things are going to get better. In the meantime, I want to encourage everyone to stay safe out there. And let's just go over some of the basics. If you're not a U.S. citizen, don't go to these protests. It's not your fight. There's enough of us out there that will go to them for you. Okay? There are enough religious persons of conscience. There are enough non-religious persons of conscience. There are enough attorneys and nonprofit groups that are going to be there to do the protesting for you and they will be there to represent petitioners in court. Don't go risk it if you are not a full U.S. citizen. And you may say, well, as a resident, I have the same rights. You do. You do. They're not really getting respected right now. And for your physical safety and for the safety of the immigration status you have, going physically to a protest is not going to be your way to fight this. It just isn't. You know what you can do? You can go apply for U.S. citizenship. If you need help, you can see my website here, visafeliz.com. Contact us. We'd like to help you apply. If you only have DACA, contact us. We can maybe help you find another avenue to get your legal permanent residency status and then become a U.S. citizen, right? In all of these situations, there are, potentially things you can do to become a U.S. citizen. But if you're not a full U.S. citizen, my opinion and my advice to you would be, don't show up to a physical protest on this. It's not worth it. And it's bound to be a few more years of chaos like this, probably in multiple cities. But let's hang in there. Let's hang in there. All right. As we end the show today, I want to remind you that we are brought to you by our sponsor, Prima.law. Prima.law is immigration case management. So if you're an immigration attorney, or if you're an immigration professional, or if you're an attorney who practices another area of law, we actually have a very flexible platform that is legal case management with a full set of tools, including electronic payments, billing, invoicing, trust accounting, notes, tasks, phone calls. We have a case management board, a great system where you can tag things in your cases so you can filter through your cases and quickly see the cases and the status and what needs to be done next and who you're waiting on. We have a full client portal and smart interviews for helping your clients gather data and send that to you in a secure manner. We have an email integration. We have built-in text messaging as well. And you can find a free 15-day trial at www.prima.law. We've done a number of technological enhancements to increase speed, stability, security over the last 10 years. And we have quite a stupendous product for you to try. Again, you can find information and a free trial at www.prima.law. Okay, now that we've stopped recording, I do see Tiago Lacerda. Bom dia. Boa noche, Tiago. Good to see you, buddy. Thanks for the comment. I see the Brazilian flag. I see the suit and tie, and I see the blue heart. I don't know what the blue heart is, but love you too, bro. I remember you. It's been 20 years, hasn't it? Let's see if I pull up over here. I actually have things going in a few different places, so I do want to be able to see all the comments that are coming in. Let's say the comments coming in, I suppose, if any. I think we might have some going on here. Here we go. Let me just make this window a little bigger. We've got some people who are joining. We're in the question and answer period. So if you're watching us on social media and engage with you here, we're going to answer questions. We'll do this in English or Spanish. You can choose. I'm going to prefer English right now. So if you're watching in English, go ahead and take advantage of this opportunity to go ahead and put your questions in the comments. If you're on YouTube, Facebook, you can do that. If you're on TikTok, I am here live. We are set up to see you, to hear you, and to take your questions live on this beautiful Tuesday evening. All right, so let's take a look at the people joining here. Boy, we've had a lot of engagement here. Yeah. Hey, if you're on TikTok or Facebook, whatever, please share this live with other people. Go ahead and share it. It lets other people know that we're here and we're giving out great advice, letting them know that this is coming from an actual attorney. So someone with a license to practice law, not someone who's guessing or trying to rile people up, trying to scare them or anything like that. This is real life engagement with a real life lawyer. All right, we're going to keep clicking here to get some engagement going. Welcome to everybody who's popping in. I see some people jumping in, some people jumping out. There we go. Here we go. D-Man 561, work permit holders, C14, in danger of deportation. If your work permit is based on CHNV parole, which is Cuban, Haitian, Nicaraguan, or Venezuelan parole, yes, you're in danger of deportation. If your work permit is based on a pending application for asylum, adjustment of status, or some other benefit, and that's pending still, you're good. Probably you're good, okay? Unless it's expired, then renew it. But if your work permit was obtained based on an asylum case that has been denied and is now closed, then it is not good anymore. So that's going to be an important distinction to be aware of for our friends online who are asking that question. Who asked that question a few times, it looks like. Yeah, please like and subscribe. Go ahead and follow us. I see people giving me thumbs up there. If you're actively watching us, please, oh, please like and subscribe. That lets people know that this is a legitimate thing, and it tells the algorithm that we're doing good things for you as well. Great. Yeah, I see a couple of people jumping in. I'm an attorney. I've been practicing law, immigration, federal court for over 16 years. And with that, I got a little bit of experience, and I tend to know what I'm talking about. And if I don't know what I'm talking about, I look it up because I know where to look. And if there's something we can do to help you, we help. If there's not something we can do, we tell you. And that's the difference between our law firm and many of the other law firms out there. Some of them will just say, yeah, we can help you. Or you might find a notary public or someone who says they're an authorized form filler or form preparer. Most of that is nonsense. Don't go along with them. You can find an attorney. And I've found that the fees that we charge in our firm are usually less than what other firms charge. And many times they're less than what one of these fake scammy notaries will do. Okay. And we'll win your case. And because we know what we're talking about. Let's go ahead and say hello to a couple other people. So hello to everyone joining today. I think we're going to end this for the Facebook Live and for the YouTube. So for those watching on those platforms, I'm going to sign off. I didn't see any more comments come in, so we will follow up on that later. But thank you for joining us and have a great night.